on this morning's docket, 106329, State of Kansas v. Story.
May it please the court, Joanna Labastida of the Kansas Appellate Defender Office for the appellant Tanisha Story. If I may, Your Honor, I'd like to request 3 minutes rebuttal.
3 minutes is granted.
Thank you. Before we begin discussing the individual trial issues, I'd like to draw the court's attention to issue 6. If this court finds that there was error within the other issues that would not warrant a reversal individually, we maintain that the combination of those errors deprived Ms. Tanisha Story of a fair trial. And with that, I will begin with issue 4, that the district court erred in failing to give an instruction for the lesser included offense of voluntary manslaughter. This court reviews that district court's refusal to give the specific instruction with the evidence in the light most favorable to the party requesting the instruction. In this case, it's Ms. Story. In order to grant that instruction, the evidence doesn't need to be overwhelming. It can be weak and inconclusive and based solely on the defendant's testimony. Voluntary manslaughter with the idea of heat of passion means that there was an intense or vehement emotional excitement of the kind prompting violent and aggressive action such as rage, anger, hatred, furious resentment, among other things.
And other than the one phone call where the paramour describes how she looked when she came through the door, what's your evidence to support that?
I think there's other evidence that supports that instruction with the idea that Ms. Story was on her way over to her girlfriend's house, and there was a very short period of time between the phone call that told her, "Don't come over, I have company," and her actual arrival.
In that phone call, was there any expression of anger or "I'm coming anyway" or anything like that? There was no evidence of that, was there?
There was just a very short response of "okay."
Mm-hmm. Okay.
Right.
So that doesn't support. I mean, the actual conversation that took place during the phone call doesn't support any kind of intense anger or disagreement.
That, I would agree, except the short amount of time, I would argue, from the phone call to her arrival would support the idea that there was no mulling over of her decision to murder someone. Maybe if she had arrived and nothing had, there was nothing out of place, there would be no emotional reaction such so strong.
Well, where's the evidence that it was an emotional reaction?
Yeah, that's what I'm looking for, the evidence that actually supports the theory that there was a heat of passion.
Absolutely. There was a jail phone call that was entered into evidence about her girlfriend's
observation
exactly, of
right.
how she looked completely different. She didn't even recognize her. Her face was a different color, and that she looked like a totally different person.
And she came in the room, did not speak, looked at everyone, and shot who she shot.
Yes.
And that's it. There's no exclamation by her at the time. No conversation at all.
That's right.
Okay.
But I would argue that that's not necessary for that instruction to be given to the jury.
Anything other than conversation that indicates anger other than the murder itself.
Her, I would say the girlfriend's observation of how she looked when she walked into the room.
And when, you would agree that provocation is required.
I would agree to some extent. I think a lot of those cases that talk about provocation are more in the sudden quarrel aspect. I would argue that this is more of almost a textbook case of heat of passion where someone walks in on their spouse having an affair and they shoot that person.
The only difference is that when you walk in, the victim is engaged in the provoking activity. here the victim was sitting in the chair, and the only contact we have is the girlfriend calling saying, "I have company." And I guess what I'm asking, is there any requirement that the victim do or say or have any type of part of the provocation? I mean, there's nothing here to show that the victim herself had anything to do with making anyone mad.
I would argue that her presence in a lady's house that she knew to be engaged with another person, dating that person, her presence there, her knowing presence there was provocation enough for the
That's
defendant.
in the record that she had that prior knowledge.
That she knew that, I believe so, yes.
Okay.
I can find that if you'd like.
Say that again, presence?
Her presence.
Presence
in the
equates
apartment.
to the presence of, where was she at? And
She was in a girl's apartment that she knew to be involved with someone else, and she decided to stay there despite the fact that she knew the girlfriend was coming over.
And there were 2 other females in the house.
Yes, I believe it was the girlfriend's sisters.
Sisters. Yeah. Certainly, would a ruling in your favor on this would be an incentive to clean living.
Yes.
Okay, thank you. I have another question.
Oh,
on
yes.
Another issue. Did you complete your argument on this one?
I did. If you'd like to move on, that's great.
You, in 2 different respects, you say the court erred in failing to give limiting instruction on the gun filing issue and on the use of the PIN number, phone PIN number. What would that have looked like? Given the way this
instructions?
evidence came in, what was that limiting instruction supposed to say here?
Well, with the serial number, I would argue that that shouldn't have come in at all, but with the limiting instruction.
I appreciate that's your predicate argument, but let's assume we get past that and maybe we did, maybe we don't. But I'm not exactly sure why this evidence came in, what it was supposed to be proving. So I don't know what the limiting instruction should have told the jury to limit it to. And I'm wondering if you have an idea on that.
Honestly, off the top of my head, I can't think of anything that I wouldn't argue against, and that maybe the state might have another idea, because it was obviously their evidence that they wanted to bring. I think that's why it was so detrimental to Miss Story, because it basically just showed kind of a general character of her being someone who doesn't follow the rules, a general criminal behavior.
But did she admit that she possessed that weapon?
No.
Well, if she's not, I mean, so then, why is testimony about the physical characteristics of a weapon that she didn't possess evidence that she committed a crime on a specified prior occasion?
I would argue that the circumstantial evidence that she possessed that weapon was pretty strong, and so the serial number being filed off would most likely have been attributed to her.
Her uncle told the police that it wasn't his gun.
Right.
Did he testify?
Yes,
Okay.
I believe he did.
What was the prior crime?
The filing off of the serial.
Was there any evidence that she did the filing?
Being the the statute for that offense says that possession of a weapon with an obliterated serial number is a prima facie case for.
Do we know when the filing off of the serial numbers occurred? Did it occur before the crime occurred here?
I do not know that.
And if it did, I mean, weren't these basically at the same time? She possessed a gun with an altered serial number. She used that gun to commit a murder. Was this really a prior crime? Didn't these crimes occur at the same time? Wasn't her possession of the altered serial number, didn't that occur at the same time as the homicide?
I would argue that the possession is a prima facie evidence of obliterating the serial number, which obviously had to have occurred prior. I mean, she didn't file it in the doorway while she was shooting, so obviously she had to have done that at some other time.
But what was the evidence that she was the one that did the obliterating?
The possession of the handgun is the evidence. I mean, they kind of stack on each other.
We're going to inference stack?
Was the gun published to the jury?
I'm not positive. I think maybe pictures of the gun, but I'm not positive.
And did those
of that.
pictures disclose the obliteration of the serial number? I mean, was that evident from the pictures or from the gun itself?
There was definite testimony about that, so.
I know there was testimony about it, but I'm trying to figure out, would this jury have determined this on its own without the testimony? That, hey, what we're dealing with here is a gun with an altered serial number.
I honestly, I can look at the transcript while the state is arguing, but I don't know that off the top of my head if they would have been able to tell that from the testimony, or I'm sorry, from the evidence.
My point is, did this testimony really tell the jury something that it wasn't going to figure out on its own? That this crime was committed with a gun that had an altered serial number on it?
Right. I would have to double check the transcript to answer that question. And I'm happy to do that. While
Any further
Wait.
presentation?
that concludes my comments at this time.
You talked about the gun. I think Justice Barr asked you about both issues 2 and 3. The other one was limiting instruction on the use of other inmates' PIN numbers. So what was the use to which the jury was limited on the fact that she used someone else's PIN numbers?
I mean, I suppose it would go towards her identity of making those phone calls, that they've confirmed that it was her as opposed to the PIN number that she used at the time. I honestly couldn't say off the top of my head what the benefit of that would be.
Was that in materially disputed that she had the phone calls and she said what she said? Didn't they record those, or? I mean, that only goes, you can only
Right.
offer, if it is 6455 evidence, which I have real question about, but even if it is, then one of the requirements, it has to be used to prove a material disputed fact, right?
Right.
And so I'm trying to find out why it's relevant to anything.
Well, it wasn't challenged at trial, and I didn't analyze it that way, other than the limiting instruction. I would just argue that it isn't material to anything and is just more prejudicial than probative of anything, and just casts the defendant in a bad light along with all the other evidence that was brought forth.
Any more questions? Thank you, counsel.
Thank you.
Good morning. May it please the court. I'm Jennifer Tatum on behalf of the appellee in the state of Kansas. I'll take the issues in reverse order unless you guys have questions that change that course. But for starters, the serial number of the gun. We did concede as part of our brief, because of the way the statute's written, it is evidence of another crime, just because if you possess a handgun with an obliterated serial number, it's considered prima facie evidence you did it. However,
That would be a question of law, and the parties can't stipulate to a question of law, so we're not bound by that concession, are we?
I'm just trying to be fair to the
Well,
defendant, but,
I understand
yeah.
that, but, and you did say then that the evidence does not appear to be admissible under 6455. We don't have to go that route.
We don't have to go that route, and I don't think it would have been admissible that way, but that's kind of where this evidence of a prior crime ends. Just as Justice Ward, I believe, pointed out, there is no suggestion in this case at all that the defendant herself did this filing off of the serial number. In fact, as far as the evidence that was presented, we don't know whose gun it was, where she got it from, or exactly when she got it. But in this case, I think Adams is the most important case to apply to it. And I believe that was an opinion authored by Justice Lukert, and I think that's why at the time we were discussing whether or not the evidence would be admissible in front of the court, that it was admitted, which is basically because it occurred simultaneously with this murder. Of course, the murder weapon was introduced into evidence. It was recovered. Not only was the gun itself introduced, and I can't tell you if the jurors took it out of the box and examined it or not. I don't know that. But there are also photographs of it. There was testimony regarding police efforts to basically put it in the hands of the defendant. DNA, fingerprints, and also brief testimony about the serial number itself. I think that testimony would have been elicited on cross-examination if it wasn't elicited by the state. So you have the practical problem of you have a murder weapon that's going to be introduced in evidence. How do you hide this obliterated serial number? I mean, do you put a sticker over it or something? Isn't that going to draw more attention to it? In the grand scheme of things, though, the question is, did this impact the juror's verdict? And I don't see how it could have under the circumstances of this case.
I don't see you arguing, but it would seem to me as a matter of common sense that if someone uses an untraceable weapon to commit a murder that has some probable connection to premeditation, that one would be more inclined to use an untraceable gun if they'd thought about killing someone. But you didn't actually argue that, did you?
I never argued that. I didn't have the facts to support that kind of argument because I didn't know where the weapon came from.
Okay.
With regards to the PIN number, I think this is even less of a problem than the serial number on the gun. I think there was testimony outside the presence of the jury and also in the presence of the jury. But in the presence of the jury, I do think the detective mentioned that inmates will sometimes exchange PIN numbers and do things like that to basically hide the calls that they're making. There was no testimony that this was some sort of crime, anything like that in front of the jurors, and I just can't imagine that they would be so swayed by that particular fact that they would disregard all of the other evidence and render a guilty verdict because of that. So I don't think that issue merits any reversal in this case. Move now to the lesser included offense instruction.
Were you conceding that's an error, but it's harmless?
No, not the PIN number, no. In fact, I don't want to concede that the firearm, the serial number, is an error either, because I think the Adams case applies, but I went ahead and argued harmlessness on that just in case.
And there's a cumulative error argument made as well by the defendant, correct?
There is, but we're not conceding any errors.
Good.
Voluntary manslaughter. In this particular case, there was no real evidence of heat of passion other than the one phone call that Justice Breyer pointed out. And that evidence, you have to understand, is coming from the defendant calling her girlfriend after the fact. And after the fact, the girlfriend says, "I saw you when you walked in that door. You look like a different person. Your face was a different color." And then the defendant, in that call and a couple others that were played to the jury, proceeds to tell her, "I know you, and I know you know. If you told me not to come, I was coming anyway." That's basically what she tells her. So she kind of corrects that notion that it was a moment of heat of passion or an emotional moment for her. We also had testimony from the defendant's girlfriend that at the time she made the initial call, the morning of the murder, when she made that call and said, "I have company, don't come over," that the defendant seemed calm. She did say that the two of them had a passionate relationship, but she denied that the defendant was an overly emotional or jealous person. As far as provocation on behalf of the victim in this case, I don't think any evidence was presented whatsoever that she knew about the defendant and Miss Bartley, or the girlfriend, being still together. I don't even know if that matters, but I can tell you I don't think that the evidence supported that the victim knew that in this case. In fact, Miss Bartley had moved in with her sisters in Kansas City, Kansas. Obviously, they went to the defendant's party that night, came home on their own without the defendant. She left again. And the victim was called over there by Miss Bartley, came over. There was no evidence of any sorts of problem with her throughout the night. In fact, that morning, after the defendant called, Miss Bartley asked her to leave, and she had put on her coat, put on her shoes, and was just waiting for a ride sitting there. When Miss Story walked into the room, Miss Story walked in, and we know that she had to come from some distance. We don't know exactly how far, and we don't know exactly the time frame, but we do know there was a period of time because the phone call and the shooting did not occur simultaneously. There was testimony of where this apartment was located at. There was pictures, there was video, and what the juror saw is that you had to park outside, walk in a door, walk down kind of a long hallway to get to the actual apartment. And what she did when she got there, she didn't knock or announce herself. She used the key that was on that key ring, opened the door, and the testimony was she kind of scanned the room with her eyes, and that she looked at the two sisters and then kind of settled on the victim who's sitting in this chair, not moving, doesn't say anything, and immediately opens fire. She fires 8 times, and she hits the victim all 8 times in particularly vulnerable areas of her body. Most of them were the chest and the head. In between the shots, at some point, we had testimony that Ms. Bartley tried to push her out the door, and that was unsuccessful, and the defendant resumed shooting after that. We had testimony that when it was over, she left, never said anything, and the victim never got out of her chair, and then the defendant proceeded to go into Missouri, ended up getting caught and seen running into her uncle's house where the gun was found, and when she was arrested, the officer testified that she was as calm as someone who maybe had just received a traffic ticket or something. Like she said, well, can I bond out later today? So then again, we have no evidence of excitement or her being terribly upset, nothing like that. No provocation from the victim. I think the cases that apply here are, first of all, Stallings and Fallon. I think those are probably the most applicable to this case. I do think this court has held, and I say that because of the Fallon case, that there has to be provocation on behalf of the victim. It can't just be that she was over at someone's house who was dating someone else. I believe the victim has to play a role in that, and this victim did not. I don't believe there's any other evidence of any sort of heat of passion. And so I don't think I think the judge was correct in not giving this voluntary manslaughter instruction in the case. If there's not any questions, I think I will stand on my brief on the remaining issues.
Any more questions of counsel?
Well, you might tell us why the school shootings was an appropriate analogy.
Okay.
And because we have a single known victim rather than unknown victims or indiscriminate victims.
In this particular case, the defense argued that, well, he made a variety of arguments. It wasn't the unified defense or the non-unified defense we were just discussing in the other case before mine, but his argument was that she didn't do it, but if she did, it wasn't premeditated kind of thing. And in this particular case, he said during his closing that how could this be premeditated if she did not know specifically it was Lakeisha Ross who was the victim sitting in that house? And there was no evidence she knew who was at the house, none whatsoever. And that argument was kind of anticipated by me. And so when he said that,
She might not have known the particular person, but she sort of knew the odd person out. She knew everyone that was going to be there and was able to identify the person she wanted to kill, right?
Right, and so when I was preparing for my closing, I was thinking about that, and I did do research, and I found that McMillan case, and I thought, well, that's a pretty good example that I could use to show that just because you don't know who the specific person is going to be, you can still form premeditation or still set out with the intent to kill someone in advance, not knowing who they may be. And so I thought that was a good example. I didn't want to belabor the point. I certainly didn't compare her to the Virginia Tech shooter or say this act is way worse than that, anything like that. It was pretty brief in terms of the closing argument, but I wanted to use that example for the jurors to understand, based on their common experience, that you don't necessarily have to, she didn't have to know it was Lakeisha Ross that was going to be in that chair. I mean, she knew that Ms. Bartley had company. That's what upset her. She knew what it meant. And I think the phone calls are evidence of that too. That's why the argument was made.
Any more questions? Thank you, counsel.
Thank you.
Reserve 3 minutes for rebuttal.
Judge Ward, I hope that your question was answered by the state's response about the firearm.
Well, I'm not satisfied. I mean, it was answered, yes. I still mull it over in my head, though.
Okay.
Thank you.
Well, obviously, the jury had possession of the firearm, so if they looked close enough, I suppose they...
So if there had been a 455 motion, had it been granted, was there a 455 hearing in this case?
I believe there was a motion in limine prior to the first trial about it.
And the court determined that it wasn't a prior crime, and so it was allowed in?
Gosh.
But if the court
Yes.
had granted the 455 motion, if the judge had said, yes, this is evidence of another crime, And for these reasons, I find it more prejudicial than relevant, and therefore I'm not going to allow it. Was the judge then not going to allow the gun into evidence, the murder weapon?
I'm sure that similar to redaction on videos and whatnot, that something could have been done to hide that aspect of the firearm.
Okay.
And also, I did want to clear up just a factual issue that was discussed in the state's argument. There was testimony from Ms. Bartley that she did tell the victim that Tanisha was coming over. So she told her, "You have to leave, she's coming over." And there was testimony that the victim said no and basically sat there. She did put her coat and shoes on, but she said, "No, I'm not going to call my mom because my mom's going to say that such and such." She wasn't really able to finish her statement on that, but that's on page 406 of volume 18, I believe.
So she caused the provocation. The provocation was she stayed at the house. Is that what your point?
That would be my argument, yes. And that concludes my rebuttal.
Any further questions? Seeing none, thank you, counsel.
Thank you.
Thank you both for your arguments this morning and this afternoon. Court will take this matter under advisement.